Hello and welcome to iChat Law. My name is Cash, your guide through the sometimes complex, often intimidating, but always fascinating world of the law. This podcast is dedicated to making legal concepts accessible, especially for those who are not lawyers. So we're trying to make sure that you understand some of this. Today's episode is crucial for anyone who might ever find themselves involved in legal proceedings in Canada. Whether it's a traffic ticket, small claims dispute, family law matter, or even just understanding the news. And knowing these terms would help you greatly. We are cutting through the jargon. We will break down 9 key terms that every non-lawyer should at least understand in order to navigate through some of the primary proceedings in legal proceedings in Canada with more confidence. You don't need to be a master in Latin to understand some of these concepts. And so it is important, and I think it's something that you should bookmark and pay attention. Before we dive in though, our essential disclaimer: this podcast provides general information for educational purposes only. It's not illegal advice. Every situation is unique. If you have a specific legal issue, please consult with a qualified, licensed lawyer in your province or territory. With that covered, now let's decode some legalese. Let's start with plaintiff versus defendant, or otherwise applicant versus respondent. These are the main parties in any lawsuits or legal proceedings. The plaintiff or applicant in some proceedings, like family law court applications, is the person or entity starting the lawsuit, claiming they have been wronged. The defendant, on the other hand, or the respondent, is the person who is responding or who is being sued, to whom these allegations have been brought themselves. Why do we need to know this? This is the absolute foundation of any civil law suit or many tribunal proceedings. If you receive a court document, summons, notice, look immediately to see if you are named as plaintiff or applicant, or versus if you're the defendant or respondent, right? Canadian context, the term applicant and respondent are very common in non-criminal proceedings. For example, in family law, which is a non-criminal proceeding, immigration appeals, some provincial tribunals, the plaintiff defendant reference or term is the preferred style, of course, and you should be aware of that. Now let's look at the number 2 on our list: burden of proof. Burden of proof refers to who has the responsibility to prove their case. It's not just making a claim, it's about backing up the claim with evidence. In criminal law cases, the Crown has that burden to prove the accused guilt beyond reasonable doubt, a very high standard in civil proceedings, right? We had I don't know, it's probably going to be a link somewhere in here of the 10 myths that Hollywood makes that are perhaps not applicable in Canada. We talked a little bit about what a reasonable doubt is in burden of proof. This term right here is that term that requires or places a duty on deciding who have to prove what and who have to do in terms of responding to what. And so you have your applicant, respondent type of a situation going on there. It also explains why the Crown presents its case first in criminal trials and why you need evidence if you are suing someone in civil proceedings. Now let's look at the term. The third term is liability. What does liability mean? Liability is legal responsibility. If someone is found liable legally, it means a court or tribunal has determined that they are legally responsible for causing harm or breaching a legal duty, like a contract or the duty not to be negligent. These are very important things to know or terms to know. And liability is the core question in most civil disputes, car accidents, slip and fall, contract breaches. Before talking about money damages, you first need to be able to establish who was in fact and indeed at fault legally. The defendant was found liable for negligence. And that brings us to the term damages. Number 4, damages. Damages is simply the monetary compensation a court orders the liable party or the defendant to pay to the injured party, the plaintiff, to compensate them for their losses, right? So again, you see how that plays out in terms of who is getting what. This can include cost for repairs, medical bills, lost income, pain and suffering, and sometimes future losses. Those are all grouped as part of the damages that one may get as a result of winning a particular court matter. Now we're in term 5. Term 5, affidavit. Affidavit is actually quite a very important document. It's a written statement of facts sworn or affirmed to be true before an authorized person like a lawyer, a notary public, or a commissioner for oaths. It is essentially given in writing, evidence given in writing under oath outside the court, and then presented as part of evidentiary process in any matter or proceedings. Affidavits are used constantly in Canadian legal proceedings, applying for court orders, responding to motions. Know that this is very important. This is very, 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 very important. Lying on affidavit is considered a crime, and in some jurisdiction, you could end up getting fined or punitive sanctions can be placed on you. So it is important to understand affidavit itself is a vehicle, a mode by which evidence that otherwise is not in front of the court can be brought before the court to help the adjudicator and the parties to understand their positions in order to be able to resolve the matter in the most fair and equitable manner. This brings us to number 6, disclosure and discovery. So disclosure and discovery is a pre-trial process term where parties in a lawsuit or civil or criminal matter are legally required to share relevant information and documents with the other side. So in a criminal law, for example, the Crown has a broad duty to disclose all relevant evidence to the defense. In civil law, both sides exchange documents and answer questions, which is referred to as examination for discovery. So those are very important terms and rights also to know, right? You are entitled to some information. This is a fundamental part of the process to ensure that everybody understand what is going on. If you are involved in the proceedings where you have an obligation to disclose information and your right to receive information from the other side, it is critical that you're aware of it, and this is all captured under examination for discovery or discovery. Number 7, and the term subpoena. Subpoena summons to witness in Canada. While subpoena is still commonly understood as the formal term in Canada, sometimes in here we refer to as summons to witness. It's a court order compelling a person to appear in court, or sometimes at a disposition, at a specific time and a place to testify as a witness. It can also require them to bring specific documents, information that they have control and have access to. If you receive one summons, you must obey it, absent a valid legal reason. Ignoring a summons can lead to an arrest or contempt of court charges. So it's a very serious document information to know. And once you receive the document, you have to pay attention and make sure that you follow the directions. Brings us to number 8 on our list of 9, adjournment. Adjournment is simply a postponement or a delay of a scheduled court appearance, hearing, or a trial to a later date. It can be requested by either side or simply ordered by the judge for various reasons, including, for example, needing more time to prepare. Perhaps there was an illness that impacted one or two of the parties, which would make it necessary and humane to have the adjournment. If you have a date, plan for it. However, if sometimes something unavoidable happens and comes up with good reason, you or your lawyer can request an adjournment. Don't just not show up, because that can lead to either losing your matter by default or a warrant being served upon you. This brings us to the last point. And before I introduce the last term and legal point, I want to take this opportunity to say thank you for being part of our community. We are growing. We appreciate you being here. We want to engage with you. And if you have very specific questions that you need to know, or you need to have some understanding or clarification on, just leave us a comment or reach out to us, and we're more than happy to assist you. So what is voir dire? Voir dire, I did mention that you don't need mastery of Latin, but voir dire is one of those Latin words that was imported into our legal concept, and it really just means a trial within a trial, a separate hearing held during the main trial, but without the jury present or the decider of facts present. Courts are required to establish their jurisdiction and also establish the parameter within which a matter is going to unfold. And in some cases, there will be a requirement, or there will be a need to sort of stop the main hearing. So let's quickly recap those 9 essential terms that we just discussed, right? Plaintiff, defendant, or applicant, respondent. Who is suing whom? Remember that. Burden of proof, who has to prove their case and how convincingly. Liability, who is legally responsible. Damages, the money awarded for the harm caused. Affidavit, sworn, written evidence, and disclosure, discovery, or examination for discovery is sharing evidence before trial. Subpoena or summons to witness is somebody who is ordered to testify or produce documents in a particular proceedings. Adjournment, postponement or postponing a court date. Precedent, stare decisions following higher past court decisions. Voir dire, that's the last one, a hearing to decide if evidence is admissible. So those are the 9 important terms that you need to know in Canadian legal proceedings. Knowing these terms won't make you a lawyer, far from it, but it would absolutely make your legal proceedings less mysterious and less intimidating. You would understand what is being discussed, what documents mean, and what your basic rights and obligations might be. So knowing these things are very helpful in terms of navigating yourself through this process. How these terms are applied can also vary slightly between provinces, territories, and other jurisdictions, and types of proceedings dependent. Like, for example, criminal, civil, or family law. Administrative tribunals have their own specific terms also. And It is so important. If you actually are involved in a legal proceedings, please get to speak to a lawyer, hire a lawyer, find a lawyer, a reputable lawyer, and proceed on whatever advice they provide you. But at least knowing these terms would help a lot in terms of trying to understand the process, right? So there you have it, 10 terms. If you have any specific questions, if you need me to elaborate and expand on any one of those 10 points, we'll be more than happy to do so. We appreciate you for being here. Thanks for joining us for this episode of iChat Law. We hope this Legalese Decoder empowers you. Have a topic you'd like us to demystify, send us an email, okay? They are in our information and description below. And we look forward to seeing you on the next one. Thank you.